A detailed analysis of some important legal news from the Hindu newspaper, September 2022. The first topic is about the UAP Act 1967. Recently, the Union Ministry has declared certain organizations as unlawful under the Unlawful Activities Prevention Act, that is UAPA Act. In this context, let us discuss what is UAPA Act, what are its important provisions, and what are its features. The Unlawful Activities Prevention Act, or the UAPA Act, was passed in the year 1967 for the effective prevention of certain unlawful activities by associations in India. Most importantly, the Act deals with terrorist activities, and hence the Act is also known as anti-terror law. The most recent amendment to the UAPA Act was made in the year 2019. And in this act, the union government is allowed to designate individuals also as terrorists. Now we closer look into the UAP Amendment Act 2019. As per the act, the central government may designate an organization or an individual as a terrorist if it commits or participates in an act of terrorism or prepares or promotes terrorism or is involved in it. Let's see some of the important features of the original act which was passed in the year 1967. As per the act, the central government has the authority to designate any person as a terrorist if he is found to be involved in any type of terrorist activity. Similarly, any company or organization which is found to be involved in any type of illegal or terrorist activity, they would also be held liable under the provisions of this act. Then the act provides for the National Investigation Agency to investigate any type of unlawful activity as per the act. And the concerned investigation officer has been given the authority to conduct raids. In the event that any property or cash is being suspected of used for terrorist activities, then the investigation agency has the authority to seize it. Further, if an individual believes that he or she has been wronged, then he or she may file a complaint with the High Court or the Supreme Court. They may also appeal to the review committee, which will be composed of retired or current judges and secretaries of the central government. Section 13 of the Act deals with punishment, and whoever takes part or commits or advocates or abets or advises or incites the commission of any unlawful activity, he shall be punishable with imprisonment for a term which may extend to 7 years and also with fine. And whoever in any way assists any unlawful activity will be punishable with imprisonment for a term which may extend to 5 years or with fine or with both. With an aim to bring a complete and a much more transparency in the judiciary, the Supreme Court is planning to live stream its court proceedings through an online right to information portal, that is RTI portal. In the context, let us discuss what is RTI, that is right to information, which legislation is dealt with it, and how the RTI Act has been evolved in India. In order to promote transparency and accountability in the working of the government, the Right to Information Act has been passed in the year 2005 with the sole object for empowering citizens to question the governmental activities, corruption, etc. Here, the citizens have the right to collect information about the public authorities, that is, the constitutional authorities, including the legislature, executive, and the judiciary. But private bodies are excluded under this act. Although right to information as such is not given in the constitution as a fundamental right, but right to know and collect information is given as a fundamental right under Article 19(1)(a) of the Constitution. Let's look at what is the fundamental right to know and to obtain information. In the state of UP versus Raj Narayan in the year 1975, the Supreme Court observed that the right to know is derived from the concept of freedom of speech that is given under Article 19(1)(a) of the Constitution. And the court further held that the people of this country have a right to know every public act everything that is done in a public way by their public functionaries, and every citizen must have a right to know about what the government is doing. Thus, the right to obtain information is an important fundamental right. The case State of UP versus Raj Narain was held in the year 1975, which widened and improved the scope of Article 19(1)(a) of the Constitution, which is the constitutional right of freedom of speech and expression. And the Supreme Court held that there was a right to receive information when the matter concerns public interest. This article talking governor, the topic which is gaining massive spectators in the recent days in the state of Kerala, where it is witnessing an ugly tiff between the governor and the chief minister. As the governor is a chancellor of the universities in the state, let us discuss what are the powers and jurisdiction of the governor in a state, to what extent a governor can act when a situation arises. The governor is considered as the head of a state in India, and there shall be a governor for each state as per the constitution. He is the constitutional head of a state, that is, it is allowed by the constitution itself. And one governor can be appointed for more than one state, that is, after the 7th Constitutional Amendment 1956. A governor is appointed by the president for a term of 5 years. There is no direct or indirect election for the post of the governor. The governor holds office at the pleasure of the president, that is, he can be appointed and removed as per the president's wish. Link is provided in the description where you can see the detailed notes. The governor appoints the chief minister of a state, other ministers, advocate general of a state, state election commissioner, chairman and members of the state public service commission, vice chancellors of universities, and he also acts as a chancellor of universities in states. To be appointed as the governor of a state, 2 qualifications are to be fulfilled. Firstly, he should be a citizen of India. Second, he should complete 35 years of age. Next, coming to the powers of the governor, it includes executive power and legislative power, financial power and judicial power. First one is the executive power. We already discussed as regarding the appointment of the chief minister, the advocate general, chairman, members of the state PSC. Again, the state election commissioner is also appointed by the governor. He is also the chancellor of most of the universities in the state. Remember, the executive power of the governor extends to the appointment of the judges of the district court also. Another important power of the governor is the legislative power, and this power extends to the control over the state legislatures, which is the prime lawmaking body. As the governor is the head of the state, he can summon or order for the sessions of both houses of the state legislature, and he can even dissolve the state legislative assembly. These powers are formal, and the governor's use of these powers must comply with the advice of the Council of Ministers headed by the Chief Minister. After the assembly elections and also at the beginning of the first session every year, the governor is the person who inaugurates the state legislature by addressing it. And the governor's address on these occasions outlines the new policies of the state government. With regard to the bill which the state legislature needs to be passed in order to become a law, the governor's assent is needed, then only it becomes a law. Also, the governor can return the bill to the state legislature, not in the case of the money bill, for reconsideration. Even when the state legislature is not in session, and the governor, if he finds that it is necessary to have a law, then the governor can pass ordinances. Also, the governor is empowered under Article 192 to disqualify a member of the House of the state legislature when needed. Next, the ambit of fraternity and the wages of oblivion is an article which relates to the very heart of the Indian Constitution, that is the preamble. One of the key words which is used in the preamble is fraternity, which means universal brotherhood. Understanding these key words from the examination point of view is very important. Let's start with the basic understanding of a preamble of our Constitution. It is said that the preamble is a key to open the mind of the makers of the Constitution. Hence, it is considered as an opening statement or an introductory statement to the Constitution, and it contains the basic values or principles of the Constitution. Here are some important points regarding the preamble. The preamble has been adopted by the Constituent Assembly on 26 November 1949. It is based on Objectives Resolution which is passed by Jawaharlal Nehru. Preamble is considered as an opening statement or an introductory statement to the Constitution of India, which contains the basic principles of our Constitution, and it came into effect only on 26 January 1950, which is then considered as the Republic Day of India. The preamble is considered as a part of the Constitution as held by the Supreme Court in the Keshananda Bharati case, the landmark case which was passed in the year 1973. And the preamble has been amended only once through the 42nd Amendment Act 1976. There are certain key words in the preamble, and from that the words socialist, secular and integrity are later on added to the preamble by the 42nd Amendment Act 1976. Remember this, the preamble has legal effect only when other parts of the Constitution exist. Apart from the other parts, the preamble has no legal existence. The simplified notes regarding the preamble is given in the description. Please go through the link.